The U.S. Supreme Court denies RFK Jr.'s request for a spot on the New York presidential ballot.
This is Dr. David Schein, and welcome to Business Law 101.
This is a truly odd situation since RFK Jr. recently suspended his campaign and has thrown his support behind former President Trump. As part of that effort, he has been involved in litigation to remove his name from numerous state ballots. The current concern is that if he is listed separately, voters unhappy with both major political party candidates will vote directly for him. The theory being that this will divert votes away from Trump. However, in New York, he has taken a different approach. His supporters have filed petitions in New York for him to be a presidential candidate, initially as a Democrat, but later after internal issues between him and the party as an independent. However, some voters, with the assistance of Clear Choice Action, a group supporting the Democratic Party, went to state court to challenge Kennedy's placement on the ballot. The argument was that RFK Jr. was using the address of a rented room of a friend in New York. However, he really lived with his wife, actress Cheryl Hines, in California. This resulted in a New York court order that removed him from the New York presidential ballot on the basis that the address used for him was not legitimate in his paperwork. Kennedy then argued that his address was a mere technical requirement and that barring him from the ballot would deny his supporters a chance to vote for him. After washing out of the New York courts, Kennedy went to the federal courts, where he was equally unsuccessful. His side raised a 1983 ruling of SCOTUS in a ballot case involving former presidential candidate John Anderson. That's right, folks, 40 years ago. In that case, Anderson argued that a March deadline to appear on the ballot was an unfair burden. At that time, the High Court agreed that this was a mere technical issue that could be overcome. However, in the current case, New York argued that ballots were already being printed without his name. Further, that there was no harm since Kennedy had already withdrawn from the race. This appeared to be the compelling arguments before the High Court. This is Dr. David D. Schein for Business Law 101. Tune in again.